Case 39, Crosby versus Cox Aircraft Company. We find ourselves in the Supreme Court in the state of Washington. Facts. The case involves a claim for property damage caused when a plane owned by Cox Aircraft and piloted by Hal Joines crash-landed onto Douglas Crosby's property. The plane was a de Havilland Otter. Its engine had recently been converted from piston-driven to turbine, and the conversion had been undertaken in strict conformity with FAA requirements. FAA certification of the plane's fuel system was still pending at the time of the accident. On December 19, 1984, the pilot flew the airplane over the Olympic Peninsula and then turned back to Seattle, intending to land at Boeing Field. However, the engine ran out of fuel in mid-flight, and the pilot was forced to crash-land the plane at Alki Point in West Seattle. The plane landed on the roof of Crosby's garage, causing $3,199.89 in damages. Crosby sued both the pilot and Cox Aircraft. His complaint raised the following alternative allegations. Number 1, that the pilot was negligent in his operation of the plane. Number 2, that Cox Aircraft was negligent in its maintenance of the plane. Number 3, that Cox Aircraft, the alleged employer of the pilot, should be held vicariously liable for all negligence of the pilot under the doctrine of respondeat superior. And 4, that both the pilot and Cox Aircraft should be held strictly liable for all damages caused by the crash landing. The pilot and Cox Aircraft denied liability and filed a third-party complaint against Parker Hannifin Corp., alleging that Parker had equipped the plane with a defective fuel system control valve, which failed to operate properly, thus causing the plane's engine to run out of fuel and forcing the pilot to make the crash landing. The trial court granted partial summary judgment for Crosby, holding that both the pilot and Cox Aircraft were strictly liable for all damage done to Crosby's property. The court did not address Crosby's negligence claims, nor the third-party complaint against Parker. The pilot and Cox Aircraft appealed. The Boeing Company and Washington State Trial Lawyers Association, WSTLA, have both filed amicus curiae briefs regarding the appropriate standard of liability to be imposed. Boeing argues that the liability of aircraft owners and operators for ground damage should be governed by a negligence standard. WSTLA contends, as does Crosby, on the other hand, that strict liability should be applied. The defendants argue for yet a third standard, a rebuttable presumption of negligence on the part of the aircraft owner and operator. So what is the issue in front of the Supreme Court of Washington? Should owners and operators of flying aircraft be held strictly liable for ground damage caused by operation of the aircraft, or should their liability depend on a finding of negligence? Holding. The court held that the general principles of negligence should control. They reversed and remanded for trial. Reasoning. Let's first define some terms. The first one is intentional tort. This is a type of tort that can only result from an intentional act of the defendant, including battery, assault, false imprisonment, trespass to land, trespass to chattels, and intentional infliction of emotional distress. Then there's negligence. 4 elements are required to establish a prima facie case for negligence. Number 1, existence of a legal duty that the defendant owed to the plaintiff. 2, defendant's breach of that duty. 3, plaintiff's damages. And 4, proof that the defendant's breach caused the injury. In other words, proximate cause. Strict liability next. So in tort law, strict liability is the imposition of liability on a party without a finding of fault, such as negligence or tortious intent. The claimant need only prove that the tort occurred and that the defendant was responsible. The law imputes strict liability to situations it considers to be inherently dangerous. It discourages reckless behavior and needless loss by forcing potential defendants to take every possible precaution. It has the beneficial effect of simplifying and thereby expediting court decisions in these cases, although the application of strict liability may seem unfair or harsh. Absolute liability. This is a tortious liability. Absolute liability can be imposed on a person even without proof of the person's negligence. Generally, owners, employers, and manufacturers are brought under the rule of absolute liability. Absolute liability is sometimes called strict liability. Absolute liability arises when a manufacturer of a defective product is held absolutely liable for the damage that resulted because of the use of the product. Respondeat superior. A legal doctrine most used in tort that holds an employer or principal legally responsible for the wrongful acts of an employee or agent, if such acts occur within the scope of the employment or agency. Typically, when respondeat superior is invoked, a plaintiff will look to hold both the employer and the employee liable. As such, a court will generally look to the doctrine of joint and several liability when assigning damages. Third-party complaint. A third-party complaint is a complaint filed against a third party by a defendant or plaintiff alleging that the third party is liable for all or part of a claim or counterclaim in dispute between the original parties. Amicus curiae. An amicus curiae, literally friend of the court, is someone who is not a party to a case and may or may not have been solicited by a party, and who assists the court by offering information, expertise, or insight that has a bearing on the issues in the case, and is typically presented in the form of a brief. The decision on whether to consider an amicus brief lies within the discretion of the court. Let's describe now the doctrine of res ipsa loquitur. Inference is the key idea behind this doctrine. Res ipsa loquitur, Latin for the thing speaks for itself, is a doctrine that infers negligence from the very nature of an accident or injury in the absence of direct evidence on how any defendant behaved. In res ipsa loquitur, the elements of duty of care, breach, and causation are inferred from an injury that does not ordinarily occur without negligence. Let's look at the four elements. Number 1, the injury is of the kind that does not ordinarily occur without negligence or is uncommon in the course and nature of said act. Number 2, the injury is caused by an agency or instrumentality within the exclusive control of the defendant. 3, the injury-causing accident is not caused by any voluntary action or contribution on the part of the plaintiff. And 4, the defendant's non-negligent explanation does not completely explain plaintiff's injury. After this case, Crosby versus Cox, airplane travel is no longer considered an abnormally dangerous activity as a matter of law. The decision is important in several ways, but this is a chief takeaway of the case, namely that by applying a negligence standard, the court basically puts airplane operation in the same category of other common everyday appliances and products, from cars to washing machines. That is a testament of how far aviation has come from the period of Gill versus Swan, wherein a case held an aviator liable for all the damages that flowed from his operation of a balloon, to the late 1980s and today, where accidents and incidents involving airplanes are the exception, not the norm.